Dean Faigman, please. Please. Thank you.
Thank you. The panel is entitled The Purpose and Efficacy of the California Bar. So I took that charge quite seriously and wanted to focus on that. First of all, I'd like to thank the committee for the opportunity to speak. It's truly an honor to appear before the Assembly's Judiciary Committee. I will keep my remarks relatively brief, at least for a law professor, and I look forward to answering any questions you have at the end. Let me begin by stating that I fundamentally agree that there ought to be a licensure exam that establishes that applicants to the state bar are minimally qualified to practice law. Every state has such an exam, although Wisconsin waives the exam for graduates of its own law school. A key question then is, what is the purpose of the bar exam? And there are two possible reasons to require a bar exam. One is the traditionally identified purpose that the exam ensures that applicants to the state bar are minimally qualified to practice law. For example, this committee's white paper, which was quite excellent, states that, quote, the purpose of a bar exam is to determine if a prospective attorney has the minimum competence to practice law. A second possible purpose is to ensure that applicants have learned in law school a set basic group of subjects as defined by the state and have the legal reasoning abilities also taught in law school that ought to accompany that doctrinal learning. The first purpose could be said to be concerned with whether the applicant knows enough to be a competent lawyer. The second could be said to be concerned with whether the applicant learned enough law in law school. To be sure, the traditional reason of ensuring that applicants are qualified lawyers is not unrelated to the alternative reason of ensuring that they have received competent training in law school. In fact, one should hope that they are related, but they are not the same. And how the test is to be validated does very much depend on its purpose. Let me take a moment to distinguish two terms that are largely confused, especially among lawyers. The California bar exam is apparently highly reliable in the scientific sense of that term. Reliability in science means consistency. If a test measures a phenomenon consistently from administration to administration, it is said to be reliable, and virtually everything you heard today is about that. Reliability, however, is only distantly related to validity. Validity in scientific terms asks whether the test measures what it purports to measure. IQ tests purportedly measure intelligence, personality tests, personality, and so forth. To determine validity, we need to know what the bar exam purports to measure: lawyer incompetency or law doctrine competency. Let me provide a simple example. A thermometer is one measure of temperature. Its reliability can be assessed by testing whether it produces consistent results time after time and with different temperatures. But being reliable, that is consistent, should not be confused for validity. A thermometer that is always 20 degrees too low would have 100% reliability and 0% validity. With temperature, the question of whether you want to use a thermometer depends, again, on what your purpose is. Inside this hearing room, a thermometer works well for our purposes. However, if you want to measure temperature on a ski slope in Tahoe, the wind chill index would be a more valid instrument than a thermometer. The thermometer might indicate that it is 20 degrees when in fact it feels like 0. The same is basically true for the bar exam. We are confident that it is highly reliable, but I have neither heard about nor seen any data regarding its validity. In fact, until today, I just heard about the NCBE's so-called validity test, which I look forward to looking forward to, but it doesn't sound like it has a lot behind it. And I would add, just as an aside, just as I would not necessarily accept R.J. Reynolds' studies on cigarettes and cancer, I would not necessarily accept the NCBE's evaluation of bar exams. In fact, I am not sure that there's even an agreed-upon purpose for the bar exam. Is it meant to discriminate between qualified and unqualified lawyers or qualified and unqualified law students? Most arguments you hear today about the declining quality of law students describe the lower LSATs and GPAs of incoming classes and the declining performance of students in law school. This is one of the reasons given for declining bar passage rates, though it hardly explains the catastrophe that is the California bar. But if test-taking ability is declining among students, you would expect a decline in test-taking on the bar, and that is exactly what has happened. In fact, when you study the statistics, what you find is that students in the top of most classes pass with very high pass rates. At UC Hastings, for example, historically, the top 25% pass with a nearly 100% pass rate, and the top 50% with well over a 90% pass rate. This suggests that the bar exam is a valid measure of law school performance. It says nothing about whether the test is valid for its purported purpose of determining whether a prospective attorney has the minimum competence to practice law. The test has not been validated for that purpose. Of course, what cut score the state chooses ought to be firmly aligned with the purpose of the test. Those falling above the line are deemed qualified, and those below the line as not qualified. But if the exam is not testing what it purports to measure, then the cut score is essentially an arbitrarily imposed threshold without basis or justification. The California bar exam, in fact, appears to be very much like the thermometer that is 20 degrees too low. I and 20 other deans of California's ABA-accredited law schools believe that the bar exam should be adjusted 20 degrees to conform to national practices. After all, if you are holding a thermometer that says that it is 62 degrees and every other thermometer in the country says that it's 75 degrees, whose thermometer are you going to believe? I will conclude by pointing out that it is certainly possible to assess the validity of the California bar exam, whether its purpose is to ensure the quality of the lawyers or the quality of what the law schools are teaching. It just has not been done yet. The California bar exam should be studied and validated. In the meantime, however, the cut score should be adjusted in accordance with the practices used by other states. Thank you.
Dean Faigman?
Yeah, if I could just, I would resist a little bit the idea that we should identify the 133 to 144 and that there's something about them that we want to get them up to 144. I think that would be a fundamental error. You know, San Diego talks about requiring 2/3 of their class to take a 4-unit MBE style to learn how to take an exam. That's shocking, but at UC Hastings, we're facing similar pressures. Our students are taking bar classes to the extent, which is generally a good thing, but they're overloading in some sense and not taking the clinical classes. They're not doing the externships. They're not learning the basic skill set of being a lawyer. And let me just emphasize something for this group. California law students and California takers are doing really well. Really well. I mean, I was struck that Dr. Bolas's graph, that if you use the cut score of New York, which I don't think New York is admitting scores, 1,789. That's a lot of bad lawyers that if New York has comparable numbers that they're admitting. And so we would have an 87% pass rate if we use the cut score of New York, and Hastings, which had a horrific, and we take responsibility for our 51% pass rate in 2016, but we would have had an 83% pass rate if our students were taking the exam in New York. And don't forget about the schools that so-called did well on the bar. Stanford had nearly a 10% failure rate. Stanford is number 2 in the country, has the best test takers in the world. And are we saying that 10% of the graduating class of Stanford is not qualified to practice law? 18% of UCLA failed the July 2016 exam. They have an average LSAT, a median of 167. Are we really saying that 18% of UCLA graduates are not qualified minimally? Davis had 30% failure rate. 30% of the class. These are students that are A students. Look at the GPAs and LSATs of students going to Davis. This is, I apologize for getting emotional about this, but those 1,789 students, many of them are my students. And I see what happens to them when they fail. I see the psychological consequences, I see the emotional consequences, and I see the financial consequences. This is not an abstract exercise. It's not about what nerds should be worried about. The cut score, that is a policy decision being made by California over 30 years, has real-world impacts. And talk about consumer protection, this is consumer protection, to attend to what the score ought to be to protect the people of California, and the students of California are part of that public. And I would like to call upon, since we have distinguished members of the bar, that they are proposing to do studies, and other than asking the law schools for information, I have not received any outreach to participate in these studies to help decide how one would validate it, whether we're validating it against the practice of law versus the what you learn in law school, which seems to be how it actually is validated these days. And so I would call upon the bar to involve the students, and there are a number of deans and professors in California, including myself, who have been trained as social scientists. I understand validation. If you want to validate on competency to practice, there are measures to do that. You define it by looking at perhaps you would expect if people who fail the bar more than one time, more than 2 times, that the number of complaints against them when they do finally pass would be higher. That would be an outcome measure that would actually look at the qualifications of people practicing law. But there are other ways to measure it, and so far as I can tell, and I look forward to seeing the study, and I'd love to get a copy of it, that was done, one study. This can be done, but it's not being done. But I just need to finish by saying, in the meantime, the dean's perspective is, in the meantime, keeping the cut score where it is just continuing to do damage to the law schools and doing damage to the state of California. And so I welcome the opportunity to study this. It's going to take some time to study, and we should change the cut score in the meantime.